Delight that we have Stephen Vladeck here today, especially on a day when all eyes are pretty much on the Supreme Court. It's particularly appropriate for him to be talking to us. I don't think that the birthright citizenship was on the emergency docket, but nevertheless, as most of you know, Stephen is a professor at Georgetown. He's also a regular presence on media, social media, and on cable news. He graduated from Yale Law School in 2004. He clerked for Marcia Berzon on the Court of Appeals for the Ninth Circuit and Rosemary Barquette on the U.S. Court of Appeals for the 11th Circuit. He has published widely in many areas, including, but not, and especially in constitutional law. And his forthcoming article it's in the Supreme Court Review, is not yet published. Is that right, Stephen? Yeah, and I think I saw an earlier draft on SSRN, and now I see this draft here, and we're just delighted that he's willing to talk. As usual, we'll hear from him for as long as he would like to speak. And then we have two of our relatively newer colleagues, Alex Sinha, who's here in the room, and Jack Rosenfeld, Zarin-Rosenfeld, who was going to be here, but unfortunately has to be showing up online, which we're also happy about. They will speak briefly, and then we will open it for conversation from the floor. And so without further ado, I turn it over to Stephen Vladeck.
Thanks so much. Thanks everybody for having me. Just do me a favor, give me a thumbs up if you can hear me okay, just so I know. Okay, cool. So I guess I'll just say a bit about where this paper came from. So I was invited to write a piece for the Supreme Court Review focused on the October 2024 term, so the term that ended last October. And in particular, what they really asked me to do was to look at the term through the lens not just of the big merits decisions, but also all of the significant rulings the court handed down on emergency applications. And I was especially grateful for that opportunity because I don't know how many of you folks saw the piece that Sarah Isgur published in The Atlantic the morning after the tariffs decision came out in February. But Isgur, who's now the editor of SCOTUS blog, wrote a piece basically saying that the tariff decision helpfully demonstrates that the real project of the Roberts Court is reining in executive power. It was not an April Fool's joke. And what's striking about her piece is how it basically depends upon ignoring almost all of the court's behavior on the emergency docket at a moment in which the court is busier on emergency applications than it's ever been, and at a moment in which, even someone like former Solicitor General Greg Garr is saying publicly that the emergency docket has swallowed the court and is actually the bulk of the important stuff, at least from a separation of powers perspective, that the court is doing. So suffice it to say, I disagreed, and I wrote a slightly snarky version of my newsletter disagreeing. But, this paper really is in some respects the receipts for that. And what I wanted to do was, try to comprehensively document all of the Supreme Court's behavior on what turns out to have been more than 30 emergency applications filed by the Trump administration just in the October 2024 term, when it wasn't even in office for the first 3 months of it, and see what broader patterns could be divined from that behavior. So, you have the paper, but just to briefly summarize the sort of the four big buckets of findings that the paper reflects. So big bucket number one is that one of the real developments you see in all of the court's rulings on Trump-related emergency applications during the October 2024 term is a remarkable amount of disrespect and disdain for Congress. And that shows up in a couple of different places. It shows up in the applications in which the court allowed the president to effectively unilaterally decline to spend mandatory appropriations. The AIDS Vaccine Advisory Coalition ruling from September, which allowed the president to basically engage in a pocket rescission of more than $4 billion in foreign aid funding. Those are quite obviously rulings that directly undermine what I would argue is Congress's most important constitutional power, the power of the purse. But you can find other contexts in which the court, throughout these rulings, really was giving Congress much less of a sort of institutional place than it was giving the executive branch. And a really good example of this are the firings of agency head cases, where, when talking about why the government was irreparably harmed by a district court injunction that held that the president, for example, could not remove without cause a member of the National Labor Relations Board or a member of the Merit Systems Protection Board, the only harm the court talks about is the harm to the executive branch. And as Justice Kagan pointed out in her dissent in the Wilcox case, I thought Congress was part of the government too. Apparently not. More than that, right? Even the way that the court is finding irreparable harm in these cases, if you actually reverse engineer all of the citations, and the paper does, you end up back in a series of in-chambers opinions by then Justice Rehnquist in the 1970s, where he said the government is always irreparably harmed when a statute is enjoined. Well, of course, not only are none of these cases about statutes being enjoined, a bunch of these cases are about the president defying statutes. And so the notion that the government is irreparably harmed when the president violates a statute and a court enforces the statute is a pretty stunning place to be in from a jurisprudential perspective. And it's a clear through line that animates a bunch of the court's rulings last summer. So, one big pattern here is just the court showing really quite stunning and shocking disrespect for the role of Congress in the separation of powers in general, and in these cases in particular. The second real, I think, innovation, and I don't mean that term as a positive one, in all of the court's rulings in these cases, is also just how much disdain the court is showing toward the lower courts, and especially federal district courts. And that's happening in a couple of different respects. So, first we have cases in which the court is granting emergency relief even after the government has defied district court rulings. That happened in JGG, the Alien Enemies Act case from last April. It happened in DVD, the third country removals case from last May. I tell my students that there's a case called DVD, and they, want to know, well, my students are actually too young for DVDs, but, my parents anyway. Right. And so, that's basically sort of letting the government get away with defiance of district courts. But even more than that, we also have the way that the court is treating its own unsigned and usually unexplained rulings as precedents that district courts are not only bound to follow in, quote, like cases, unquote, but that the court has chastised district court judges for not following in at least 3 different cases, in a context in which what the district court is not following is an order with no explanation. That really is, I think, a stunning amount of disrespect toward lower courts and toward the role of district courts in particular. Justice Gorsuch, in his concurring opinion in the NIH case, specifically called out Judge Young from Boston, Judge Murphy from Boston, and then the district judge in Boyle, Judge Boardman in D.C. Or in Maryland. That's quite striking, given that the court can't bring itself to write opinions or even explanations in these cases. So one is sort of shirking or degrading Congress's role. One is demeaning and undermining the district court's role. But then I think the third piece of this is it would be one thing if these developments were part of a consistent trend in how the Supreme Court is processing emergency applications. If the way the court is treating irreparable harm were part of a broader trend, if the way the court were balancing the equities was part of a broader trend, maybe at least you could defend the court's raw power to change the rules as long as it's being consistent. But I know you guys are all shocked to hear this. The court is not being consistent in these cases. And And sort of a couple of examples that I have in the paper, if you compare how the court approaches balancing the equities in cases coming from the Trump administration during the October 2024 term versus balancing the equities in cases not coming from the Trump administration, you see a very remarkable difference. So the paper talks about two cases, Net Choice versus Fitch, the Mississippi social media age verification case, and South Carolina versus Doe. This was a transgender bathroom case where the Supreme Court denies emergency relief, even though it expresses sympathy for the applicants on the merits, on the ground that the balance of the equities weighed against intervention, right? The very thing that the court had not been doing in the Trump cases. That suggests that the court is perfectly happy to follow the traditional criteria as long as President Trump is not in the caption. So maybe the argument goes from my friends on the right, maybe it's just about the executive branch, that the Supreme Court is just showing proper respect and proper deference toward the executive branch of the federal government. Well, then if you look at the Biden era cases, you find similar inconsistency. So the paper talks in some detail about one Biden case in particular, a case with the deeply unhelpful caption, United States versus Texas. We have a lot of those. This was the challenge to the Biden administration's immigration enforcement priorities, where a district court, a single judge division in Texas, had issued a nationwide injunction blocking the administration's immigration enforcement priorities. The Fifth Circuit denied a stay. The Supreme Court also denied a stay by a 5-4 vote, even though on the merits, it eventually ruled for the Biden administration 8-1. What that suggests is that this notion that the executive branch is just getting a thumb on the scale in favor of the merits doesn't actually explain, right, why the Biden cases came out differently at the emergency application stage than the Trump cases. So all of this is just to say that when Justice Jackson, at the end of her dissenting opinion in the NIH case in August, referred to the court's behavior as Calvin ball with a twist. She says the only rule of Calvin ball is that there are no rules. We have two rules, right? That one and this administration always wins. That really does seem to be a fair description of most of what the Supreme Court was doing on Trump-related emergency applications during the October 2024 term. This brings me, though, right, to the last point, which is not all of them. And there really were two especially visible outlier moments to this narrative that I think are perhaps the most telling evidence and the telling indication of what the court is really up to. So the first is, speaking of unhelpful initialisms, the AARP case. This is just the pseudonymous initials of the lead plaintiff.
Listening to the webinar.
What's really sort of funny about that case is when I started writing about it for my newsletter, I got an angry email from the head of media relations at the AARP saying, please stop calling it the AARP case. I said, well, when the Supreme Court stops calling it that, I'll stop calling it that. But anyway, the AARP case, this was the case where the Supreme Court, shortly before 1 a.m. on a Friday night, intervened to basically prevent the Trump administration from removing a group of alleged alien enemies in the Northern District of Texas to eventually El Salvador. And the question is, why would the court drop everything to intervene in the middle of the night in that case, when in so many of the other cases it bent over backwards to rule for the Trump administration? And so as the paper suggests, I think the best answer is because just 12 days earlier in the JGG alien enemies case, the court had said that before you can remove individuals as alien enemies under the Alien Enemies Act of 1798, you have to give them notice and an opportunity to be heard. And here was evidence that the administration was about to defy that. So defying district court, no problem. Defying Supreme Court, we're getting out of bed to issue an injunction at 1 a.m. That's the first data point. And then the second data point is the oral arguments last May in what's now the first iteration of the birthright citizenship cases. So as you guys may recall, the court had oral argument on the procedural question in those cases, that is to say on the legitimacy of the universal or nationwide injunctions that the district courts had entered blocking the birthright citizenship executive order. one of the most striking exchanges in that oral argument started with Justice Kagan raising the specter of the administration losing all of these cases on a retail basis in district courts and then just not appealing. And she said, if that happens, how can we actually ever, clarify the law in a way that will cover everybody? So Justices Barrett and Gorsuch both picked up on that exchange. Justice Barrett asked the Solicitor General, wait a second, are you really saying that we won't be able to get the last word? And Barrett extracted two concessions from Sauer. The first is she got him to say, oh, no, we totally accept Cooper versus Aaron, shorthand for we accept that we have to listen when you, the Supreme Court, tell us what the law is. He said, we totally accept Cooper versus Aaron for the Supreme Court. We just don't follow that in the lower courts. That was the first thing he said. And the second thing he said was, and we will appeal back to you on the merits in these cases. A concession that Barrett memorialized in footnote 18 of her majority opinion. That's why we had the oral arguments today. I mean, the only reason why the administration took this case back to the Supreme Court is because it promised it would. Why was that? Why were those the necessary concessions to get Barrett and Gorsuch to stand down and to rule for the administration last May? Again, because both of those concessions were about protecting the Supreme Court's supremacy. To hell with the supremacy of lower courts, right? To hell with the need to comply with lower court rulings. So all of that leads to the real thesis of the paper, which is that if there's a unifying theme cutting across all of the court's behavior in the Trump-related cases last term, it's not about reflexively ruling for Trump. It's about protecting the court's power and nobody else's. Right? There's a really bad Chris Rock movie from the early 2000s called Head of State, where his opponent in the presidential election says, God bless America and no place else. Right? That's basically the theme of these rulings, right? We are supreme and nobody else is. And, the rest of the paper in the more prescriptive part talks about why I think that's a deeply myopic and ultimately self-defeating approach for the court to take. That being convinced of its own supremacy, but willing to undermine the supremacy in their spheres of Congress and the lower courts is going to do three things. One, it is going to only increase the incidence of confrontations between the executive and the courts. We're already seeing some of that going forward. Confrontations that will necessarily require the court to spend finite capital that it does not have an unlimited reservoir of. Two, in the interim, what the court is doing by letting the executive act until those confrontations is further empowering the executive. I mean, as the paper suggests, I don't think it's a coincidence that shortly after the Supreme Court's ruling in Nome versus Vasquez-Perdomo in September, the ICE raids case from Los Angeles, that's when we saw the surges in Portland and in Chicago and then eventually in Minneapolis once the court had greenlit the ICE's behavior. We're going to see more of that as the court enables these actions in the interim. And then third, in the long term, my real concern is that this attitude runs the risk of actually delegitimizing the lower courts at a time when the lower courts are being subjected to unprecedented attacks by the president, the attorney general, the deputy White House chief of staff. The court may not be leading those attacks, but it's not doing a lot to stand up against them. And at the end of the day, the real problem is that the court may believe that it is meaningfully different from lower federal court judges. But I'm not sure that the median voter understands the difference between disbelieving in the power of an unelected judge and disbelieving in the power of an unelected justice. And so the paper tries to suggest that if this pattern continues, if this is the court's MO going forward, even just on emergency applications, the real institution that suffers in the long term is the courts. And that's, obviously, at least from my perspective, something that we, and especially the Supreme Court, should be mindful and wary of. So that's basically the paper. And I'm really looking forward to your feedback.
Thank you very much. Our first reactor to the paper is Alex Sinha, who teaches constitutional law.
All right, thank you. And thank you so much for this paper. Can you hear me? Yeah, great. So I just want to first of all say that I'm a fan of your work. I've been following your work for a while. I think we first met when you were at American. I was still at the ACLU working on national security issues. And I followed your work on the Guantanamo Bay military commissions. I use your textbook for my national security class. And I follow your work on the court, including this essay. So I'm really excited to get the chance to talk about it. I also think I want to say just out at the top of this that I really think it's important for people who are careful, thoughtful observers of the court to take the time to document these kinds of trends. Because my sense from talking to lay people about the shadow docket and even other law professors sometimes is that people are inclined to think of it as some sort of procedural thing. Maybe it's sort of interesting to law nerds. Maybe it's aberrational in some way, but the substantive implications of it are not necessarily apparent. And I think documenting the trends is really important and is going to serve a valuable function going forward. I also think, though, I'd be neglecting my duties if I didn't try and apply some pressure to what you're trying to argue. So I'm going to do that now. So your central point here, that this is the language you have on page 6, the most plausible unifying theme of the court's behavior, and the behavior here is the increased use of emergency applications or ruling on emergency applications to benefit the current administration, is just that the justices were and are attempting to preserve their supremacy as such. And you go through and you give these examples and you kind of point out how this is a fairly self-defeating approach, right? Like this is dangerous for them. It's tanking the public's confidence in their work. It's making it more likely that we're going to embrace some sort of legislative adjustment to their jurisdiction or to their size or to their terms or whatever, right? It's not necessarily a smart approach. And so as I'm reading that, I'm thinking like, no, I think you're right. It isn't a smart approach, but that raises a really important question. And you ask the question at the very end, and I kept waiting for the answer. And you ask the question on page 42. The harder question, this is what I have here. The harder question is whether the justices in the majority don't fully recognize that these are the costs of its behavior, or whether they do and just don't care. And it seems to me that if they recognize the costs and don't care, then it cannot possibly be that they are trying to assert their supremacy, right? The only way they would be asserting their supremacy as the general explanatory factor for this conduct is if they don't realize the harm they're causing for their own future supremacy, their own future legitimacy. And I think it's not as hard of a question to answer why they're doing this if we take a different theory of why they are trying to give so much emergency relief to the Trump administration. And it seems to me, and I'm not as careful a watcher of the court as you are, and I concede that, but from my perspective, the salient explanation is actually just that they like the Trump political project and they buy in on a very deep substantive level, and they're willing to torch some of their credibility. They're willing to torch the lower courts to advance that. They won't necessarily go along every single time. If it looks like they're going to be defied, they're going to step in and say, well, listen, we don't appreciate you suggesting that you might not listen to our orders. But other than that, by all means, emergency relief that we'd never have granted before, sure, why not, right? And, I take your point that they're reducing the role of Congress, but we have a self-loathing Congress, right? Like this is the least, at least in my lifetime, certainly, which isn't necessarily that long, but certainly as long as I've been paying attention, I've never seen such a supine Congress, right? And there are many Republicans in Congress who are totally fine with Congress's prerogatives being just overridden by the Trump administration, by the executive branch, right? So I'm wondering if the better explanation is, I'm sure you've thought about this, so I'd love to hear your views on this. And you do concede, obviously, that there is favoritism toward the Trump administration taking place here in the balancing of equities, right? But why is that not just the full explanation or the primary explanation rather than a secondary major theme, right? That's my first question. My second question, and I'll stop with this, is just a more open-ended question about judicial supremacy. And I think it's a less pointed question, right? So a lot of con law professors use Marbury versus Madison to teach judicial supremacy, right? We go to that case, which features some gamesmanship by Justice Marshall trying to issue orders that, he knows he can't issue certain orders because people aren't going to comply with them. He's trying to build the credibility of the court. And one of the things he says is his famous line. I'm sure people in the room are all familiar with it. I have the language here, right? It is emphatically the duty of the judicial department to say what the law is. And one of the things that troubles me about the use of the emergency docket is, it strikes me that what the court does when it uses the emergency docket is it decides what the law is, but it doesn't tell us what the law is. It's not saying what the law is. It's just stipulating that somebody wins, and usually the same party, right? And in a society like ours, in a representative government, in a society that's supposedly or purportedly or ideally governed by the rule of law, the people are supposed to have an understanding of what the law is, what the rules are, who's likely to win, and why, right? And when the government goes to the court for emergency relief and the relief is granted without explanation, as is so consistently the case and as you document, I am struck by the inability of the public to make sense of what the law actually is, because the court isn't saying what it is, it's just deciding what it is. So I just invite your thoughts on that question as well. Thank you so much. I really appreciate this.
Stephen, would you like to respond?
Sure. Just very briefly, because I don't want to take up any of Jack's time. So I guess, Alice, I guess there were three things there that probably are worth. So first, I guess I'm not so persuaded that the sort of obliviousness narrative is so implausible, or I'm sorry, that the sort of willful narrative is so implausible, because you could believe that all you care about is the short term, and be willing to sacrifice the court's long-term power and legitimacy, right, in the name of maximizing your short-term ability to do whatever you want. I don't know if that's where Justice Alito is, but I could see a world in which that is not an implausible summary of how he approaches his job. So that's just on that point. To your second question is, of course, the harder one, which is, why isn't this sort of, general favoritism with maybe a couple of red lines, right, just the right answer? That the court is just generally hospitable to the Trump administration and it has a few stopping points. You might be right, Alice, but the question is, why were the red lines the red lines? Right. And so at the very least, I think it's worth trying to figure out what it was about AARP and what it was about CASA, not the result, but the sort of the exchanges in the oral argument that provoked the pushback that we didn't see in other cases where I thought there were even better arguments for it. Right. If we expand the sort of the aperture beyond the 2024 term, right? Why was the Illinois National Guard case, not a reflexive win for Trump, right? Why is he going to lose Lisa Cook? And it seems to me that, like, yes, there are some lines the court is not going to cross even for this president. We already saw that with tariffs. I think today's oral argument suggests we're going to see it with birthright citizenship. I'm curious in trying to figure out what those lines are, because they don't have any coherent connection in substantive doctrine. And it seems to me that, however the median votes on the court are quantifying and qualifying their authority, this is doing a lot of the work. Like, the cases where they feel like their authority is being jeopardized are the ones where they're pushing back. And if their authority is not being jeopardized, they don't care. That's I think why you and I end up probably in much the same place. To the third, on the not saying what the law is, I have to confess, I would have thought, I've been writing about this for 8 or 9 years now. And, as you might expect, I've been the subject of a fair amount of pretty harsh critiques, especially from the right. I would have thought the notion that the court has to explain itself would not be ideological and would not divide people into partisan camps. The court itself, right, has always said that its authority comes from its ability to persuade. You can't persuade in an unsigned, unexplained order. And so I guess, I'm really struck by how much the emergency docket is, in some respects, the real apotheosis of the worst behavior of the Roberts Court, not the rulings we disagree with on the merits, but the notion that they just don't actually owe anybody any explanation, in context in which the absence of explanation makes the court look very bad. Like, I think part of the deal of being a judicial supremacist, and I am one, is that you have to accept that the court's going to get a lot of stuff wrong. But this is not the court getting stuff wrong. This is the court behaving wrong. And I would have thought that would have been lower hanging fruit for reform and lower hanging fruit for, cross ideological agreement on ways the court could behave better. And it's really quite striking how much some of the justices have dug in on not needing to explain themselves. I think that's a real bad look for the court.
Thank you. I'm going to call on Jack, who is online. Can we bring Jack on? Bring him onto the main screen. And while Jack is speaking, I'm happy to keep a queue.
Great. Nice to see everyone. Thank you for this great paper, Professor Vladeck. I think Alex was definitely right to point out that the procedural aspects of this are not as consequential or well understood, or sorry, not as consequential, but oddly sort of more apparent, and the substantive problems underneath are what deserve to be brought out first and foremost. But I tried to sort of think of this through just the lens of procedure. And so that's where I guess my two questions come in. So, the first question is, there's a way to read this whole story as civil procedure is the bad guy because litigation takes a long time. And every litigation has a lengthy interim period between filing and whatever the final resolution is. And so if you think about the posture of a lot of these cases, the Trump administration takes some action, they get sued, the district court enters a preliminary injunction. The administration then takes an interlocutory appeal from that rant of a PI and also then seeks a stay of the PI pending the appeal. Basically, let us keep doing the challenge thing while the appeal is going through of only the preliminary injunction, right? We are so early in the case here. And so if you think about how the court will eventually decide the merits of the PI question, the actual just was the PI right, they'll get there with full briefing, the benefit of a full appellate decision. It'll look like the ordinary procedures that we usually think of and desire. But when you think about the emergency application track, the stay question that is so much the focus of this paper, the procedures are just nothing like we would ordinarily want, the compressed time frame, limited briefing, limited record. And so given that posture, how unfamiliar, unrecognizable these consequential decisions look to our sort of normal procedural posture, I've been trying to puzzle through how the court justices sort of understand their role. What are they doing? Are they doing something really judicial here, or are they doing something else? And I think there's a way to read Professor Vladeck's paper that they might just be doing something else. When it comes to the emergency docket, they don't really see themselves as performing ordinary appellate review of lower courts. Instead, what they're doing is something different. They're just deciding, they are deciding which of the litigants gets to control the material reality on the ground while the litigation drags on. And so maybe this framing helps make sense of some of the descriptive analysis. So the justices are inconsistent with how they treat the merits, irreparable harm, equities in the case. And maybe it's just because those factors are not relevant to a justice's conception of who should control the interim status quo over in the broad run of cases. It may be just that a justice prefers to give the same repeat litigant control over the interim status quo because of some preferences that have nothing to do with the case, have nothing to do with what would be developed in a full procedural development of the case. It could just be the Trump administration's ideology, their electoral accountability, their political support, something about the characteristic of the litigant and not anything to do with the merits of the PI or the equities in this particular case. And so my first big question is there something that feels persuasive about this description? Is this something that's just outside of our ordinary conception of judicial procedures? Is this something that's more managerial, more political, that is occurring case by case, but is really operating on more systemic grounds? And then my second sort of smaller and hopefully more optimistic question is, towards the end of the paper, Professor, you suggest that one possible long-term consequence is legislative efforts to rein the court's power to rein in the court's power. And I would just note that from a procedural perspective, that may not necessarily be a bad thing at all. There's nothing special about a single 9-justice court having the final say over the timing and consequences of nationwide litigation. And we can have a functional procedural system in all sorts of ways. And so is it possible that one optimistic outcome of this mess is a restructuring of what our final decision makers look like in a way that really decentralizes the power of who gets to control the real world in the interim of our sort of regular litigation system? So that was a lot, and I hope it made sense, but I really, really enjoyed it and look forward to hearing.
Thanks. It did actually. So spoiler alert. My next paper, which is it's going to be the foreword in the Harvard Law Review, is basically, Jack, about this. And building off of, so the opinion that I think comes the closest to trying to take a normative shot at rationalizing the court's behavior is Justice Kavanaugh's concurrence in Casa. And Kavanaugh spends 12 pages trying to explain what he thinks the court is doing. And he says, what we're really doing is we are trying to provide what he calls nationally uniform interim answers to important questions of federal policy, both because there should be nationally uniform interim answers, and because if there are going to be nationally uniform interim answers, better they come from us than from Amarillo or San Francisco or whatever other cherry-picked district judge you can find. So there are 3 problems with this approach. The first is that it is completely lawless. And it's completely lawless in the sense that the Supreme Court's authority is governed by both Article 3 and a series of statutes the court had until recently interpreted consistently to limit its ability to provide emergency relief, Jack, in ways that had nothing to do with whether we'd be better off with a nationally uniform interim answer. No surprise that Justice Kavanaugh has been one of the justices least likely to follow the traditional standards of review in these cases, but that should still matter, right? Ditto, not deferring to district court fact findings in these cases. Like, yes, you might be able to tell a blue sky story of why we should be able to act as a 9-justice district court, but that's neither the Constitution nor the statutes we have. So that's just the first problem. The second problem is, even if you buy the theory, Kavanaugh didn't do it in Casa, right? Like if your whole argument is that we should be providing nationally uniform interim answers, what was the nationally uniform interim answer in Casa? They didn't provide one. That was the whole point, right? We only had a nationally uniform interim answer because shortly after Casa, 3 different district courts issued different types of effectively nationwide relief, and the Trump administration appealed but did not seek stays. So it's lawless, and he didn't even follow it. But even if you could get past those 2 problems, right? The third problem is, if that's what the court is doing, then no one should be suggesting that its interventions have precedential force, because then it's not doing law. And, in some respects, this is how the court handled emergency applications in the old days. You had individual circuit justices who would decide, sometimes after in-chambers argument, sometimes through in-chambers opinions, Jack, very much this just straight equity, like thumbs up, thumbs down, we'll save the merits for if and when you come back to the full court. And, that system had its warts, but no one ever mistook what Circuit Justice Marshall or Circuit Justice Douglas or Circuit Justice Rehnquist was doing with the Supreme Court, settling the law of the land. And I think part of where we are right now is that we have the worst of both worlds. We have a court that thinks it can do these things, despite all of the procedural obstacles, and insisting that its lawless interventions are law. And that, so I think you could fix this in either direction. But what really I think comes through the more that you fold in that history is just how completely, how do I say, warped, right, the current moment is. Like how much the current moment is taking the worst of column A and the worst of column B. To your last point, I mean, I'm a Mets fan, so I'm of course optimistic. Right? You have to be. Restructuring. Yep. Restructuring finality, Jack, I think is one possible way out of this, where we go back to the old school version where we were okay with district courts entering injunctions that might be wrong. I think another way out of this is just for Congress to reassert more control in general over the court's docket, right? Something it did historically, I think to mostly salutary effect, and something it's been out of the business of doing since 1988. But the relevant point is not that there's a magic bullet. The relevant point is that, like, we should be able to persuade folks who are more sympathetic to the court than I am that its current behavior in these cases is serving no one well, least of all the court. And that's, I think, the first step is acceptance, and then we'll figure out what the solutions are.